Another one of our favorite true crime and legal update cases. This is the case of Rebecca Scofield versus Ashley Guillard. Now, Ashley Guillard is also known as the TikTok psychic. This case resolves around the Idaho 4 murders and the fact that it's a defamation case. It's in civil court in Idaho. And it was with the magistrates until Ashley Guillard, well, she did some stuff. Let's just get to it. But Ashley Guillard is the TikTok psychic who took it upon herself to solve the crime of the Idaho 4 murders and decided that Rebecca Scofield was the person who did it, without any evidence, regardless of the fact that the actual police came out and said that Rebecca had nothing to do with it. She carried on a lot, like hundreds of TikToks, wouldn't back down, cease and desist, threatened a lawsuit. Nope. So Rebecca Scofield finally did sue. And we've covered this before. So, Rebecca actually had attorneys, but Ashley Guillard decided to defend herself. And she received some grace from the court in regards to filing and all, and like as you should with your pro se, a little extra consideration. But basically, it didn't really help her much. I think she would have did better with an attorney. I know she didn't want to hire one, but if she wanted to protect all that money that she made from from actually accusing Rebecca Scofield of actually committing these murders with no evidence and defaming her. And the Idaho 4 that we're speaking of is Anna Kernodle, Kaylee Gonzalez, Madison Mogan, and Ethan Chapin. I called them the Idaho 4, not disrespectfully, but just to make it shorter. And we want to honor the victims in that case always. So young that they lost their lives, We cover these cases to get justice for all victims, the victims of this murder, and also the victim in this case, which is Rebecca Scofield, who has been defamed. Now, a while back, a judge ruled that yes, Ashley Guillard had made multiple defamatory statements and that he was putting it up to a jury to decide the damages, that there was going to be no more back and forth, that Ashley Guillard had the information to know that Rebecca Scofield was not the murderer. Someone else was arrested. The police came forward and said she wasn't a suspect. She wasn't even in the area. She doesn't know any of the victims. There was nothing. And when Ashley Guillard was put to test to actually provide the information that makes you say this, that say that these statements can be true, she said to the court, they are true because my spirit guides tell me they're true, and my spirit guides don't lie. They have always told the truth. Just because you don't understand the truth or my spirit guides doesn't mean that it's not true. But that wasn't a legal argument. I'm not sure what kind of argument it was, but it was not a legal argument. And it got pushed aside by the court. They gave her ample opportunity to further explain herself in the interrogatories, the things that go back and forth, that you answer the questions. She would not say that nope. She just said she got the information from her spirit guides during a reading, that this is how she solves crimes, and that it's true. And she wouldn't back down. She didn't make a deal, didn't stop, didn't pull anything down. She's currently lost her TikTok channel based on all of this. And she's currently in France. Well, she was in France in July. I'm not sure where she is right now. But we've got stuff to discuss because finally we got a ruling. But let's get up to speed first before I go over with the ruling, because I am going to read. This is going to be the one thing I'm going to read to you guys. Okay, so now on October 25th, this is all just happened this fall. Okay, the motion was filed against, Ashley Guillard had filed a petition to the court after the summary judgment that the magistrate judge put down to say that you're guilty of defamation and we're going to court we're going to go put it to the jury on what your damages will be. He made a summary judgment. Like, he can't, because the filings back and forth, she was not making her deadlines. She was not answering like the motions correctly, whatever, in regards to the questioning. And she kept doubling down, and there was enough information there. The judge said that it was proven that the statements that she made, that she admitted to the judge she admitted to everything that she said, because she says it's true. But the judge sided with Rebecca Scofield and said it's not true. There's enough evidence to say it's substantially not true, and that you should know it's not true, and that you are actually coming forward with malice to actually say these things about Rebecca Scofield, which proves defamation. So since the defamation part has been proven, it was going to go through full damages. Now, so Ashley Guillard filed a very clever motion to withdraw her permission for the magistrate court to settle this case, and asked for a district judge to take it over. She wanted it removed from the magistrate court district into the district court as an appeal. And because she was actually filing against she wanted the summary judgment overturned, and she wanted a whole new proceedings to start in district court. Yeah, she did that. Yeah, she's like, I don't like what you did, so I'm just gonna move it someplace else and see if I can do better. But you see, there's legal proceedings on how to do that. And although she followed the procedure right, she just didn't have standing or a reason to do it. There has to be a legal precedent actually for moving it to the other court. Something had to have happened. There has to be a reason to overturn the other judge. Voila. So a motion was filed by Rebecca Scofield's legal team seeking to strike portions of Guillard's supplemental brief. They argued that Guillard introduced arguments and materials beyond the scope permitted by the court, which included speculative evidence unsupported by the record. In other words, talking about what her spirit guide said, talking about these stories about who Rebecca knew and who she influenced, and that now she was changing her story to say Rebecca wasn't the one that did the murder. She hired somebody, and started with this narrative in the motions. October 30th, Ashley Guillard submitted a second declaration in support of her motion to overturn the partial summary judgment, reiterating her claims of bias against the magistrate judge and challenging the legal basis of the earlier ruling. Because in her ruling, she literally said that the magistrate judge was biased against her because he didn't recognize her spiritual beliefs, her spirit guides, as knowledgeable in her, and that it was a violation of her rights, her First Amendment rights, her religious and freedom, to be able to put this forth as an argument. Okay, now we know that your practice of religion is never an argument in a legal court. It can be a supplement to something, but it can't be you don't have to follow the rules because of it. Okay, but she's trying to say that the judge, because she kept mentioning her spiritual beliefs, was prejudiced against her. But that's not it. The judge, in all of his rulings, he was very kind as far as extending deadlines and trying to lead her to, the proper motions and things to actually fill through, and trying to get her to answer the questions adequately, where the information was coming from, or what she had to substantiate the claims. But she kept going with the legal argument or her version of a legal argument, that it was her spirit guides that told her, and her spirit guides don't lie. And just because the judge doesn't believe in it doesn't mean it's not true. Now, belief and facts, two different things. You can believe in your spirit guides all you want, but that doesn't make it a fact of law in the court. And that was the problem. It's not that the judge was prejudiced. It's that the judge has to act on fact and law. And there is no fact and law in the statement that it's true because my spirit guides told me. So on November 4th, a status conference was scheduled by the court aiming to address procedural issues, including deadlines, resolving pending motions, setting a potential timeline for trial or other hearings. But nah. didn't move forward because we still had this appeal to go to the from magistrate court to district, pending a judge's ruling over there that was overseeing it in the appellate. Okay. So a procedural order consolidating filings related to Guillard's motions, in other words, putting them all together because she was haphazardly all over the place, because she's trying to overturn the judgment and yet she's trying to reassign the case to another court district, and all at the same time. And so she was making duplicate motions and they were getting noise. So they streamlined everything. The streamlining the review process for the case, the order did not resolve any of the substantive issues about whether it was going to district or whether they were going forward to trial yet, because it was still being held up by this appeal by Ashley Guillard. But it emphasized the efficiency in addressing the volume of motions that were filed. Okay, so now what happens next, right? Where do we go from there? Well, we were sitting there, and I read all of that. And I was like, damn, it's going to be like next year before we hear anything. Like, I don't know. Like, I can't even imagine like what is going on, right? But lo and behold, on the 13th of November, this little goodie dropped in my box, and I'm going to read it to you. This is a memorandum in decision in order in regards to the filing back and forth from magistrate court to district court in the Rebecca Scofield versus Ashley Guillard case. Okay, memorandum decision in order. Pending before the court is defendant Ashley Guillard's motion for reassignment. Having reviewed the record and the parties' submissions, the court finds the facts and legal argument are adequately presented and that oral argument would not significantly aid its decision-making process, and it decides the motions on the parties' briefing. In other words, the request to have a hearing in regards to all of this, moot. You filed enough. I have all the information. That's where we're gonna leave that. District Idaho Local Civil, and it gives the citation, rule of order, the court may provide for submitting and determining motions on briefs without oral arguments. Okay. For reasons stated below, the court denies Guillard's motion to reassign her case to the district court. The case arises out of the tragic murder of 4 University of Idaho students in Moscow, Idaho. Following the murders, Guillard posted videos on social media alleging, based on her clairvoyant abilities, that plaintiff Rebecca Scofield had a romantic relationship with one of the students and was involved in the murders. After Guillard refused to cease and desist posting information about Scofield, Scofield filed this defamation case against Guillard, docket number 1, which would be the complaint. Now, Guillard's motions was docket 75. A lot of stuff back and forth, wouldn't you say? Memorandum and decision order 1. The clerk of the court randomly assigned the case to the magistrate judge. After Scofield appeared, the parties were notified in accordance with the District of Idaho General Order number 324 that a magistrate judge had been assigned to conduct all proceedings in the case, including any trial and entry of final judgment if both parties consented. See docket 11. Therefore, both parties filed written consents to the magistrate judge conducting all proceedings. See docket 17 and 17.1. Both Ashley Guillard and Rebecca Scofield agreed to the magistrate court. As the case proceeded, the magistrate judge ruled on numerous matters. For example, because Guillard had initially failed to timely respond to Scofield's complaint, the clerk of the court entered a default judgment against Guillard. That was docket 5. After Guillard responded and Scofield moved for a default judgment, the magistrate judge granted Guillard's motion to set aside the entry of default and gave her an additional 21 days to respond to Scofield's complaint. They were very kind to her. And you would want them to be, regardless of any arguments or anything back and forth. If you're pro se, you want a little guidance. Like it, and I'm actually glad they did. This would be fair. Okay. Therefore, the magistrate judge ruled on several other motions, including Scofield's motions to dismiss Guillard's counterclaims. Guillard had filed a counterclaim on not only against Scofield, but also against all of her attorneys. Yes, of bad legal manners, saying that, it was an erroneous lawsuit and that they were part of the whole thing. Okay. To squash summons to Scofield's counsel, to squash a subpoena, and for sanctions against Guillard, docket 49 in 55. Eventually, Scofield moved for a partial summary judgment and for leave to file a claim for punitive damages. Okay. After hearing oral argument, the magistrate found Guillard had defamed Scofield and granted Scofield's motion for partial summary judgment, docket 74, on page 20. Further, the magistrate judge ruled Scofield had established a reasonable likelihood of proving by clear and convincing evidence that Guillard's conduct supported punitive damages. In other words, like malice. Like she went over it above. Like a dog with a bone. Like she wasn't letting it go. In response to the magistrate judge's decision, Guillard filed a request for reassignment to a U.S. district judge, which is a form documented posted on the court's website. This document requests that the reference to the magistrate judge be vacated and that the case be reassigned to a district judge under 28 U.S.C. 636 Rule 73B of the Federal Rules of Civil Procedure, docket number 75. At the same time, Guillard also filed a motion, Rule 59 of the Federal Rules of Civil Procedure, to alter or amend the judgment. Specifically, Guillard requested the court reverse the magistrate judge's ruling granting partial summary judgment for Scofield and allowing Scofield to assert punitive damages. The magistrate judge referred Guillard's request for a reassignment to a district and to the extent necessary per Rule 59 motion. In support, the magistrate judge relied on Ninth Circuit authority that only a district judge may rule on a request for reassignment. So he sent it on over. And a district judge may rule on a motion to withdraw consent to the jurisdiction of a magistrate judge under Section 636C, number 4. Therefore, the clerk of the court randomly assigned the pending motion to this court. Here's your analysis. As Guillard acknowledges, both parties voluntarily consented to the magistrate judge proceeding in this case. Docket 84, page 2, conceding that all parties consented to the magistrate jurisdiction. Shortly after the magistrate judge issued its decision on summary judgment and punitive damages, however, Guillard filed the request for reassignment to a United States district judge, which she obtained from the court's website. That form, however, is not intended for the purpose of reassigning a district judge to a case after the parties have already consented. Rather, the website expressly states that a reassignment will occur after the clerk of court receives the request if the parties have not already consented, and that once you have consented to magistrate judge jurisdiction, you cannot later request reassignment to a district judge using that form. Magistrate judge consent, District of Idaho, and it gives the form. Nonetheless, the court construes Guillard's reliance on the form as a motion to withdraw her consent to the magistrate's judge jurisdiction under 28 U.S.C. and Rule 73B. Because Guillard apparently misunderstood the form's purpose, she did not file a brief in support of her request to withdraw her consent. To the extent she complains about the magistrate judge, those arguments are either made for the first time on reply in docket 84 or in her brief in support of her Rule 59 motion on docket 77. In accordance with the federal court's practice of liberally construing pro se filings, the court considers those arguments for purposes of resolving Guillard's motion to withdraw her consent. In other words, they're giving her a free pass and saying she wants to withdraw consent. It's obviously she's trying to, even though she's not using the right format. Okay. A party does not have an absolute right to withdraw her consent to proceed before a magistrate judge in the cited case of Sabaka versus United States. However, it provides that the court may, for good cause shown on its own motion or under extraordinary circumstances shown by any party, vacate a reference of a civil matter to a magistrate judge. Similarly, Rule 73 provides that on its own, for good cause, or when a party shows extraordinary circumstances, the district judge may vacate a referral to a magistrate judge under this rule. In the footnote is clarification that Guillard argues the clerk of the court should have filed her request for reassignment under seal. No authority, however, supports Guillard's assertion that a party's motion for reassignment after all parties have consented should remain confidential. To the extent Guillard relies on the court's website as support for her assertion, she misconstrues that information. In other words, she's getting the information from the website. Well, she's not actually using the information appropriately from the website. She's not reading it. So, the Ninth Circuit has noted the extraordinary circumstances standard is a high bar, which is difficult to satisfy and intended to prevent gamemanship. Neither mere dissatisfaction with the magistrate decision nor unadorned accusations that such decisions reflect judicial bias will suffice. Sorry about that, guys. And they also say, see also Seabourn Cruise Line Limited versus Goldman, okay, in December of 2022. The case law is clear that dissatisfaction with the magistrate judge's rulings, absent other evidence, is not sufficient to vacate consent. We're shown here, but rather the plaintiff simply was displeased with magistrate's rulings on the motion to dismiss. Further, an appeal, not a reassignment, is the appropriate avenue to address any alleged erroneous ruling. Guillard's primary challenge to magistrate judge proceedings in this case appears to be her concern that his impartiality is impaired, that he is biased against her. In support of this challenge, Guillard contends that due to the magistrate judge's personal lack of belief in Guillard's spiritual practices, i.e., claircognitives, intuition, tarot card, and oracle card reading, he acted in a way that impeded upon Guillard's right to an impartial tribunal. In other words, she couldn't get a fair trial because he didn't believe that she could activate her spirit's guides to tell her the truth. Docket 71 at page 14. The magistrate's judge's lack of impartiality and inherent bias regarding Guillard's spiritual practices and its plausibility impeded upon his ability to judge the case without bias. After reviewing the entire record in this case, this court is unable to locate any support for Guillard's accusation that the magistrate judge was biased against her. Rather, his rulings are based on the record, rely on applicable and persuasive authorities, and are supported by sound legal reasoning. Further, the magistrate judge's interactions with Guillard during the summary judgment oral argument were both polite and patient. Indeed, he even stated that there may be valid use to spiritual intuition in tarot card readings, but that to avoid summary judgment, Guillard needed admissible evidence to establish a genuine issue of material fact. In an attempt to persuade this court that the magistrate judge was biased against her, Guillard misrepresents the record. For example, she asserts the magistrate judge's inability to be impartial is exemplified by his continuously mocking and ill statements about her spiritual beliefs and practices. Guillard, however, fails to cite any support in the record for this accusation. And as stated above, the court has been unable to locate any indication in the record that the magistrate judge exhibited any bias. Further, Guillard states that the magistrate judge made specific statements demeaning her spiritual beliefs and practices, calling them baseless, delusional, fanciful, lacking common sense, and implausible. To the extent the magistrate used these terms, however, he was directly quoting Supreme Court authority on Rule 12b-6, standard for dismissal of frivolous claims. The magistrate judge was not characterizing and did not characterize Guillard's beliefs and practices using this language as Guillard misrepresented. Moreover, as Scofield notes, the magistrate judge has not ruled against Guillard in every instance. Rather, he has frequently ruled in her favor. For example, he set aside the clerk of court's default entry against her despite Scofield's objection, and denied Scofield's motion for default judgment, docketing fees. Further, he denied Scofield's request for attorney fees, denied a motion to sanction Guillard, and sui sponte granted Guillard additional time to respond to Scofield's request for admission. These rulings contradict Guillard's assertion that the magistrate judge was biased against her. Guillard's other arguments in support of withdrawing her consent are that the magistrate judge's rulings are erroneous and that reassignment is necessary to prevent an unnecessary appeal to the Ninth Circuit. Erroneous rulings, however, do not constitute extraordinary circumstances warranting reassignment. If Guillard disagrees with the magistrate judge's rulings, the proper method to challenge them is by appealing. In this case, Guillard must file with the appeal with the Ninth Circuit once the judgment is final. Upon entry of judgment in any case in which the parties consented to the magistrate judge, an aggrieved party may appeal directly to the appropriate United States Courts of Appeals from the judgment of the magistrate judge in the same manner as an appeal from any other judgment of the district court. In summary, Guillard has failed to establish any extraordinary circumstances justifying reassignment of this case to a district court. The record does not show the magistrate judge was biased in any manner towards Guillard. Instead, the timing of Guillard's motion to withdraw her consent in her Rule 59 motion, filed shortly after the magistrate judge granted Scofield partial summary judgment and leave to assert a punitive damages claim, indicates that Guillard's real motivation is to avoid the magistrate judge's ruling. Guillard's only recourse to challenge those rulings, however, is an appeal following a final judgment. The court does not condone Guillard's unsupported disparagement of the magistrate judge to obtain a new judge. Because the court denies Guillard's motion to withdraw her consent to the magistrate judge, it does not address her Rule 59 motion, which remains pending before the magistrate judge. It is ordered that Guillard's motion for reassignment to district judge is denied. Dated November 13, 2024, by Amanda Brailsford, U.S. District Court Judge. Ta-da! Like, I just had to read that. Sorry, guys. I just had to. I did. It's long. I know. But for those of you that want to read it later, because I misspoke a few words and got tongue-tied. There it is again. On that, I'm going to check for questions. But anyway, we are back to the same magistrate judge who just had to wait all that time while she said all that stuff about him. And he will still probably be very professional and treat her with much grace as he did in the past. And we have a summary judgment, and we will now wait until we get an actual trial date so that Rebecca Scofield can finally be free of this.